Okay, now the room's going to start booming because I don't normally talk so softly. So I need to know how to control myself. We have an hour for this session, but actually I don't have a lot of slides. What I was hoping for was to be able to do sort of a dialogue. I know we have a panel following as well, but as I go through, if you have questions and it's really burning, just jump in. And then some of these you can fall into the panel as well. I think it makes it for a bit more exciting. Now, in terms of the discussion for today, it's focused on why have a whistleblowing policy. Should we have a whistleblowing policy? Actually, a couple of preliminary points, especially since it's being recorded and I'm a lawyer after all. Whatever I say here today for the record is entirely of my own views. It does not represent the views of my organization. I just got to be very, very clear about that because I have gotten into tricky situations before. And all discussions is just for discussion purposes. They are not meant to reflect any real life current cases going on, okay? Now with that, so feel free to ask questions as we go along. Now, in relation to whistleblowing, actually, at least 10 years ago now, I think, or roughly about 10 years ago now, I had an opportunity to interview J.Y. Pillay at that, and at that point in time, he was the chair of the Singapore Exchange. And one of the things that I asked him about was whistleblowing. And, you know, about whether Singaporeans generally and Asians generally are reticent. They do not want to whistleblow because it's not our style to whistleblow. We rather save face, keep quiet. We may talk behind people's backs, but we don't say it up front and get people into trouble. And he said, what, rubbish. He felt that the whistleblowing culture was ripe back then even. And I mean, this was just his words, okay, and I have no proof one way or the other. He said that in the civil service, for example, people would whistleblow left, right, and center. So he seemed to think that there was a culture of whistleblowing. Is there? One's not sure. Why isn't there? If it isn't there, usually because of repercussions. That's the main element, okay? Now, I've said a few things about whistleblowing already, but what is whistleblowing? Let me get into my slides. Sorry, you are not seeing some of the slides, and it's going to be a problem because you're missing out on 1/3 of the slides. You probably have to push the table back, yes. So all these preliminary slides, it's fine. It's all planned to adjust the table for you. Okay, what is whistleblowing? Thank you. What is whistleblowing? Now, there are many, many definitions out there in terms of what is whistleblowing. And, sure. So, what is whistleblowing? Okay, I'm distracted. There are many definitions in terms of what is whistleblowing. But I can't say that there is a single official definition as such. It depends on the piece of legislation that you look at. It depends on the jurisdiction of the country that you pick up from. And if you want the slides, don't take photos. And I'm hoping no one's recording me as well. Drop me an email. I'm happy to send it to you. So no issues, okay? So coming back to the definition, what we put out there is policies or procedures ensuring disclosures will be handled seriously. It is, so in a proper manner. A whistleblowing approach really suggests that there is an avenue for someone to raise concerns in a manner which allows the concern to be addressed. That's really what whistleblowing is about. And as you raise those concerns, you also want to ensure that there are no repercussions for you. Now, I'm sure there are people in the room who have, at different points in time, raised concerns and incurred the wrath of someone or other. And it's just very difficult, right? So because of that, you need some degree of protection. In terms of the protection that you get, historically, at least in the Singapore context, it needed to be in the policy of the company. So it is corporate to corporate, charity to charity, basically organization to organization, and depending on what policy you have within your organization. If you have a very loose policy that says that, you can raise any issues, you can call this hotline, or you can drop an email to this email, and it stops there, obviously there's no protection. So you need a policy which goes into depth. And I've been involved in policies or drafting and putting whistleblowing policies in place where the policy goes into hundreds of pages. And to maintain the anonymity of whistleblowers, we have post boxes that you can just drop things into, for example. But nowadays, people are very happy to do things social media, right? Through social media. So anyways, so that's whistleblowing. Who is a whistleblower? It's the person who is whistleblowing. As simple as that. What is the whistleblowing all about? It could be internal, and very often it is internal. Okay? So internal whistleblowing is an issue within the organization. It is, it could be a safety issue, it could be a corruption issue, and so on and so forth. And we'll go through some of that. Sometimes the whistleblowing is to a regulator. And in more recent times, this is really in the last decade or so and not before, you have provisions in the law that allow you to whistleblow to a regulator. Okay, so that's more the external whistleblowing. Now, when it comes to external whistleblowing, I think organizations are a little bit more careful. They do not want employees running off to whistleblow. So what they want to do is to try and see if it can be managed internally. So policies, again, will be put in place for that purpose. I'll come back to some of these in a little bit. Now, what does whistleblowing cover? So there's a whole bunch of things, and this slide, it's by no means comprehensive. Your whistleblowing issues could cover bullying. So now we have the Prevention of Harassment Act in Singapore. It's not a very old act. Previously, if there was bullying, you had no protection under the law. Now you have that act, it gives you some degree of protection. Not to the whistleblower, but the act of bullying. So at least there's some degree of protection, and so indirectly to the whistleblower, there's a degree of protection. Theft, fraud, corruption, I put those in a sort of a same basket. As far as corruption is concerned, there is whistleblowing protection, whistleblowing provisions available. And in fact, the law makes it mandatory that if you are aware of the receipt of funds coming from corruption or other serious offenses, you must whistleblow. You must go up to the regulator and tell them about that. Otherwise, you are criminally liable as well. Okay, so I don't want to say it's just money laundering. It's not. It's really proceeds from any criminal activity. So funds flowing through any bank account, funds received, whether in or from a bank account, outside of it, doesn't matter, which relates to any serious crime, not just corruption, not just embezzlement. So sometimes I joke that even for murder, which is a serious crime, and you receive funds for that, that is something that you need to disclose. Okay? Harassment is like bullying. You have the legislation. Things like workplace safety. I have put a slide up on the legislation itself, but let me just touch on that very quickly. The Workplace Safety and Health Act in Singapore was introduced in 2006. That is the first act which offers employees protection if they whistleblow about a health and safety hazard within the organization. That remains the only piece of legislation that accords employees protection as far as Singapore is concerned. Okay? I share an anecdote here. Some years ago, in an employment-related matter, there was an individual who was going to be terminated. Actually, he wasn't going to be terminated, but he claims that he was passed over for promotion. And he claimed that he was passed over for promotion because he highlighted certain risk that existed in the company. And the risk related to certain safety issues as well as corruption issues. And the corruption issues were not about money flow, but the corruption issues were about how certain decisions were made or by not taking into account all of the relevant facts when those decisions are made. So very hard to pin it down, right? It could be just a very personal thing as well. But he took it very seriously. And it was part of a group company. He went up to the parent co and he made a complaint up to that level as well. And we had to see how best to manage the scenario because you didn't want the situation going out to the press, for instance. So I don't think he was terminated at that point in time. I can't remember the exact set of facts. It was a case that I was involved in. But we didn't want to terminate him because he could end up creating bigger issues for the company. All right? So just moving along, the whole range of different types of whistleblowing here. I put this slide up front, and I want to come back to it at the end as well. I'm sorry it's really tiny. In terms of sort of managing the whistleblowing process, I put it up front because I wanted to sort of give you a perspective, and then as I talk, and then we come back to it later. So essentially, assuming there is a violation, whether it's a crime, whether it's a unsafe act, whether it's harassment going on in the office, anything at all, there are various unusual activities going on. What do? You need to have, assuming you have the whistleblowing policy in place, you need to have investigations set out. Who does the investigation? How do I ensure that I have the right people doing the investigation without their allegations being made about biasness? How do I ensure that? So I got to make sure that my team that handles the investigation is seemingly independent. All right? So that's one. And then making sure that that team is also adequately trained. When they have conducted the investigation, there needs to be proper documentation of that. Otherwise, it's again going to be allegations of bias, or you didn't do it properly, you didn't give me a chance to speak, and so on and so forth. Having reviewed the matter, the investigation team should then decide, do we take it further? Do we bring in senior management? How do you manage it? So it's a process that takes time. Depending on the nature of the violation or the nature of the whistleblowing activity, do I now, and this becomes an issue for the company, do I now need to take this out to a regulator? So just now I mentioned that there are certain activities that occur where you do need to disclose to the regulator. And through this investigation, if something like that comes up, the company needs to make a call as to whether you need to take this to a regulator. And it might seem simple enough, because if I go back to my previous slide, it might seem simple enough because I'm just talking about fraud, I'm talking about misconduct, theft, workplace safety and health. So it appears very isolated. But actually, it's not so isolated, because my issue could go a little further, and it may end up having a company consider whether the offense involved is one which is a reportable offense. So when I talked about regulators, I mentioned workplace safety, there's the SGX, there's the MAS. But over and above that, we have certain offenses which are reportable offenses. And so the company then needs to make a decision as to whether this is an issue that I now need to report. And if I don't report, what are the consequences for the company or for the organization? And when I say organization, then let me bring it down a little bit lower instead of being at 50,000 feet. Organization is just an entity, right? Doesn't mean anything. The council in a not-for-profit or the board in a for-profit is the sort of mind of the organization. So then the board needs to make that call at some point in time. When do I make the leap from senior management to board to make that call, and then for the board to do so? And what if the activity was a reportable offense and it wasn't reported? Where does the offense lie? Company, board, management, how do I manage it? No easy answers, but it's just something that you need to be thinking about. So when we talk about whistleblowing, it's not just about, I got bullied, I want to be able to whistleblow. I did not get promoted, I want to be able to raise this issue. It's not always about personal issues. Sometimes it goes a lot further. Oftentimes it goes a lot further. In terms of the process, it is also important to ensure that employees have training in terms of how it works, what the investigation process is going to entail and so on, so that they have the confidence level of utilizing the process that's been made available. All right? Now, moving along, what I thought I'll do in the next few slides is just share what's going on in other countries. So I picked out a few countries, not exhaustive, where there are whistleblowing legislation. Whether it's effective or not, we don't go there, okay? We look at least we have a piece of legislation to start with. So picking up with Malaysia, introduced this Whistleblower Protection Act 2010, in 2010. It draws a lot of inspiration from the UK Public Protection Act. I have it in the next couple of slides. Now, the main reason why this one was introduced, the primary reason, was really to combat corruption. And then it goes on to say to combat corruption, but also to combat other wrongdoings by facilitating, by encouraging whistleblowing to be made. The legislation provides clearly for protection of the whistleblowers. So it does say that the whistleblower details will be maintained. Confidentiality of the whistleblower information will be maintained. There is, and this is important, immunity from civil suit. What do I mean by that? If I come out and I say something about you and you're not happy, you can sue me for defamation, unless I can justify I got facts. And if I have no facts, you can sue me for defamation. And when you sue me for defamation, the problem with that is I have all these facts, but then I get dragged into litigation for no reason. This act avoids that. It gives me protection. I cannot be sued. Okay? Scope of the law, it's not company, organization specific. It covers anyone, the public. So it's very much similar to the UK. And then in terms of the investigation process, of course, it calls for the whistleblowing to be done in good faith. It must be based on honest and reasonable grounds. Let me pause there and say, I'm not sure how many lawyers are there in the room, but one of the concepts I've had a lot of difficulty grasping is reasonable. Is anyone in the room reasonable? Okay. When you look at the law, we will always say you've got this reasonable man test. And who's the reasonable man? We look at the average individual in that kind of level, whatever that level we're looking at, and then we say we benchmark against that. The older I get, the more I realize that there is no such person in existence, me included. So, but that's the law, and that's what we live with, and that's what I argue till the cows come home. Now, in terms of the process again still, the whistleblower doesn't actually have to provide hard evidence, and this is important. So the test, in a sense, is set fairly low. The bar is set fairly low. So long as I have reasonable facts to support me, I can provide that. I don't have to provide supporting evidence. And then it's for the agency to investigate. So the bar is set quite low. Okay, moving into the UK. Sorry, excuse me. Moving into the UK, like I said, the UK was the one that has had the Public Interest Disclosure Act for a very long time. So the Malaysian one drew inspiration from that one. In terms of the approach, it's very much similar to the provisions I explained just now, the Malaysian provisions. Generally, it applies to the public, and you can whistleblow on anything if there's a public interest that's going to be affected. So any wrongdoing. In relation to protection for who do you sort of do the disclosure to? In the first instance, is always disclose it to your employer. You may also, in certain instances, disclose it to certain designated official bodies as such. Now, the disclosures that can qualify for protection, again, it's a reasonable belief that there's a criminal offense, that there's a breach of legal obligations, there's a miscarriage of justice, and that's probably the most important one, miscarriage of justice, and then danger to health and safety of the individual. Okay, but the miscarriage of justice is the one that carries the largest load in a sense, and there's the overriding public interest element that we look at. Again, must be made in good faith and with a reasonable belief that the allegations are substantially fair, very much similar to the Malaysian one for obvious reasons. The UK, additionally, in the charities arena, has whistleblowing guidelines which have been issued by the Charity Commission. So in this regard, employees of charities can report concerns about serious wrongdoings at their charity. So the guidelines say that they can do this about their charity, but under the purview of the Public Interest Disclosure Act. Okay, so the guidelines are useful because it sort of helps spell out, as far as the charitable organizations are concerned, certain express guidelines in terms of the steps you can take. Now, the intention of the whole guidelines is really because charities have come into the spotlight a lot, not just in Singapore, but across the world as well. And in the UK, the idea was to see how we can have increased disclosure, ultimately increased protection for the public at large, for the employees as well. Why do I say public at large? Charities usually live off donations as well. And so there's a public interest to be protected. You want to ensure that the funds you donate go to the purposes that they were donated for. And when I say purposes they were donated for, it doesn't mean that I said you should use this for X, you must only use this for X. Not necessarily. It is to be used for what that charity is intended. And the council at the charity can decide how they use it and determine it. There are various other protection requirements, like the protection of the individual, the privacy of the individual to be protected, and so on. Won't go into all of that. Just by way of quick comparison, I wanted to show up the US as well. Let me pick up the center one first, the Sarbanes-Oxley Act. The Sarbanes-Oxley Act was something that was introduced just before the Code of Corporate Governance was introduced in Singapore in 2003. Sarbanes-Oxley came about because of the entire Enron collapse, if you remember, 2002. My favorite ad is still the Christmas advertisement where there's a sign, there's a suggestion that it was Arthur Andersen shredding papers and throwing it out as snow. Do you remember that one? If you do, then you're in my generation. So anyways, the key reason for the Sarbanes-Oxley was because of, presumably, despite the financial sector having a lot of disclosure provisions in their listing rules, in relevant legislations that protected the institutions, there was always a concern that Enron highlighted a concern that there wasn't sufficient disclosure coming through. And so Sarbanes-Oxley basically introduced a whistleblowing provision and granted whistleblowers protection. So this is not just employees, but granted whistleblowers protection in a reverse sort of way. If the employers retaliated, or if a third party retaliated against a whistleblower, then the third party would be subjected to civil and criminal prosecution potentially. So Sarbanes-Oxley was a good start, and it kind of awoke, I think, all of us into this whole concept of whistleblowing. But yet our Code of Corporate Governance in 2003 did not have express whistleblowing provisions within the code. That came in much later. The False Claims Act, that's something which is general. Essentially, whistleblowing about parties who have been defrauded by, parties who have defrauded the government and liability that comes out of it. It's in a sense a whistleblowing piece of legislation, although it's not something which is unusual because most jurisdictions would have something similar as well. Dodd-Frank came after Sarbanes-Oxley, again for the financial sector, and the purpose was stated as aimed at promoting financial stability. And it introduced this whole concept of a reward, in a sense, for whistleblowers. So there was a whistleblower bounty program. Someone who volunteers original information leading to successful enforcement with monetary sanctions would get awarded 10 to 30% of the penalties imposed. So you get money for whistleblowing. You think there's such a thing in Singapore? Don't have? Have. I will tell you soon. So coming to Singapore. Now, not all these legislation are strictly about whistleblowing, but when you look closely at the pieces of legislation, there are provisions that does suggest that you need to have whistleblowing. That's one point. Second point is, I think in the more recent years, each one of these regulators or agencies have introduced and have strongly recommended whistleblowing to be, policies to be put in place. Now, the first act I want to just start off with is the Workplace Safety and Health Act, because I think that's the piece of legislation, as far as Singapore is concerned, that expressly introduced protection for employees if they whistleblow on a health or safety issue. Now, the protection is along the lines of you cannot be terminated from employment. Question is that effective protection? Why do I ask that question? Because, you know, if I'm working in company A and I whistleblow about something within company A, it's just natural for the group that I whistleblow against to close ranks. And if that group is in sort of working in cahoots or very close to management, they will all close ranks. And although the law says I cannot be fired, is it easy for me to continue working in the company? Tough, right? But we still have to start somewhere. And so the law says I cannot be fired. So at least I continue to have a salary for what it's worth. But it is an important piece of legislation, and then we see a lot more coming along the way. Now, going up to MAS, Monetary Authority of Singapore, this one is more an encouragement. It's not in the MAS Act, but encouraging all FIs, for example, to institute a whistleblowing policy within the organization. And the whistleblowing policy is intended to be very wide to cover unethical behavior as well. Then we have the next two pieces of legislation, the Corruption, Drug Trafficking and Other Serious Crimes, Confiscation of Benefits Act. It's a mouthful. And the Prevention of Corruption Act. Both of these sort of similar in the sense that they were tightened in more recent times to introduce laws to say you need to whistleblow and to introduce laws to say the whistleblower will have protection. So for the PCA, the Prevention of Corruption Act, that became more important as well. That may be a reason why we've had more corruption cases come up. I don't know. It's possible. All right? But it gives you an avenue to highlight. In terms of the CDT, SCA, that's the Corruption, Drug Trafficking, and Other Serious Crimes Confiscation of Benefits Act. The idea there was really to manage proceeds that come from drug trafficking, proceeds that come from any other serious crime that I talked about just now. Again, the provisions here provide that any whistleblowers will be given immunity or will be protected if they provided information. Okay, and the whistleblower could be the party actually part of the crime. Now, there's another piece of legislation, the Terrorism Financing Act, that also has whistleblowing provisions within the Act. Employment. Now, employment infringements, you can whistleblow anonymously to the Ministry of Manpower. The moment it goes in anonymously, then you don't need to worry about it, but at least there's a policy put in place. Competition law. So I don't know how many of you know what competition law is. That's one of my main areas of practice other than corporate governance. Now, competition law, if you have done something wrong, you can go to the Competition Commission and plead leniency. So if you are the first one to go and you have provided information that the commission, the regulator, does not have, then you'll be lucky and you pay $0 in fine. Now, one of the bigger cases in Singapore that we handled, I acted for the leniency party. They paid $0 in fine. There were 4 parties in total. The remaining 3 paid a total of $9 million in fine. So it's not small money, it's big money, okay? So that's one, leniency. And it makes sense, and it's something that a lot of countries have. But the other one, which is not in the legislation, but which has been introduced in terms of policy, is if you know that a company is acting anti-competitively, and you have enough information, you can go to the Competition Commission and you can whistleblow. And if you are right, you can get up to $120,000 in cash, no questions asked. I don't have numbers as to how many times it has been used, but I have been told that it has been used. And I say up to, I don't know how much has been paid out, but I have been told that it has been used and money has been paid out. There's at least one case for a fact I know that we are handling still, and so it's confidential, where the whistleblowers were employees of one of the parties. And they will get a reward. Okay? So whistleblowing in that sense has come a long way, just to let you know. Let me just very quickly check. Okay, so I move along still. Now, whistleblowing in Singapore from a charities perspective. So the charities have their own code of corporate governance, in a sense. The code has been amended. There's a 2017 version. It will come into force on the 1st of January, for what it's worth. Now, within the code, it is now mandatory for you to have whistleblowing policies in place. Of course, this is for the larger charities. You need to have gross annual receipts or total expenditure of 10 million or more. And for IPCs, gross annual receipts or total expenditure of 500,000 or more. So that's the criteria. If you're smaller than that, then you don't need to. Why do we need this? Basically to strengthen governance. I mean, it's as simple as that. And do we want to trust individuals who are going to whistleblow? Not always, but yet it gives another avenue to try and ensure better governance. Why do I say that, another avenue? I might have the best governance processes put in place in the organization, but sometimes, somewhere, if someone's going to commit fraud, it's not easy to pick up. It's just not easy to pick up. And you know, somebody else may be noticing this and realize that there is an issue, provides an avenue for that individual to raise the issue, to complain about it, and yet be protected. So I see it as another avenue to ensure governance. I don't see it as a negative. I don't see it as a, wow, you tell on me, how dare you kind of attitude. So that's the Charity Council. This slide is just to give you an idea of some, and it's by no means exhaustive because there's so many charities out there, charitable organizations as well, which have their own whistleblowing policies. So these are just some of the main ones: Community Foundation of Singapore, Singapore Cancer Society, Red Cross, National Kidney Foundation. Actually, more than one of these have from time to time been blasted for lack of governance within the organization. Okay? Not just at Singapore level, at international level. Now, pros of whistleblowing. Why do I want to have a whistleblowing policy? It's sometimes good because it acts as a good warning system within the organization. It's like alert. It provides a stopgap, like I said just now, a governance mechanism, and allows management, board, or council to deal with the issue, try and solve it internally, don't have the press picking up on it, because when the press picks up on it, it becomes a big pain. Sometimes, unfortunately, we don't fully appreciate the issues that come up. It just gets, sometimes it just gets very complicated because, you know, at the end of the day, it's individuals involved. And you may think that you're not doing anything wrong, but it's how the issues come out can also create a problem. So we put out the NKF example there. It's long over, and I don't want to rehash issues, but I just want to highlight how the case came about. It was all about the golden tap, right, unfortunately. Now, if there was an issue, you want to be able to deal with it internally. Unfortunately, this wasn't dealt with internally. It got picked up by the press. The press wrote an article about it. It became a bigger issue. And if we had stopped there, it may have gone away, but the individual concerned decided to sue for defamation. I mentioned defamation just now. It's just one thing after another riding on and on without us taking a step back and thinking through. And that whole escalation, in a sense, actually got the public saying, huh, what the heck, kind of thing, right? So, right, you may be completely right, but no one's going to look at it anymore. You may have had all these things based on your hard work from money from somewhere else. Don't care. It's a question of what the public perception is. And unfortunately, when you're part of large organizations and there are ways and means for people to hype things up, being a bit more humble helps, in a sense. So that one came about because of the press raising an issue, because of the defamation action that came out, and because of public perception causing the whole problem. Okay? And then it ended up with bigger issues being discovered. So in a sense, it was a good thing that it happened, because then the bigger issues got discovered and matters had to be resolved. Now, another thing about the pro about whistleblowing, essentially, the aim is to try and improve upon or sort of set a higher bar in terms of the standards of accountability within the organization to ensure that improper behavior is dealt with, everyone behaves with a certain minimum decorum, in a sense. We pulled out a case here from the UK, and this particular case concerned certain activities that occurred at a hospital, and over a period of 4 years roughly, it was found that between 400 and 1,200 patients had died. Actually, there's a similar scandal in India currently. A number of children have died. Okay? And the reason for them passing off is because of poor care. And the result of this, and when this was discovered, the community started losing trust as far as the hospitals are concerned. So they refused to want to go there for treatment. There was an inquiry, and the inquiry revealed that there were two key reasons for the substandard care. One is, okay, let me pause there and give you a bit more background. What happened in this case is that the hospital actually was doing the right thing. They went out there and they got external parties to come in, do an audit. How accurate is your audit? How accurate is the audit? Who audits the auditors? I'm not, again, casting spurs on anyone here, but I've seen enough and lots of white hair to be able to say, auditor, sorry, I realize I have an auditor on the panel. Oops. I'm very passionate about this topic, and so sometimes I just fly off the handle, so that's why I hesitate when I'm videoed. No, but the point remains that it's not everybody, but there are occasions when audits are not completely done properly. And it may be because we don't go sufficiently into depth. It may be because the information that's provided to the parties conducting the audit is limited, because you're relying on information as well, okay? So the external audits, unfortunately, had failed to detect various problems that occurred. But internally, there were individuals who had raised issues. The staff had raised issues. Staff had complained. But the board of the hospital refused to listen to the staff. And the consequences are dire. You have people dying. So the inquiry went into that. Those results came out. There were subsequent consequences that came about it. Another one, in relation to Singapore, bringing an example out from the Workplace Safety and Health Act. Here, there were certain employees in a construction company, and this is public information. They raised concerns about how the practices within the company were ongoing. And it related primarily to cranes and the way the cranes were managed and the safety lapses involved in that. The employees wrote directly to the Ministry of Manpower because when they raised it within the company, nothing was being done. And that was a real issue. Part of the reason why they decided to raise this was because they've had several incidents, but there was a crane which toppled in 2014. And they wanted to be sure that this was arrested, basically. It doesn't continue. The 2014 incident was not reported to the Ministry of Manpower by the company management. And that's a serious offense because the Workplace Safety and Health Act requires or mandates that, well, if there's injury, you need to notify the Ministry of Manpower about it as well. So here, when the employees wrote in, the Ministry of Manpower did conduct investigations and did take action. I guess there's been enough, in a sense, evangelizing, so the employees were aware that they could go down this road, and so the protection was accorded as well. Now let me bring in another case. This is in relation to, so this is not a Singapore case, it comes out from the States. It's in relation to the pharma industry, this particular case. We had this particular company, Celgene, which was accused of having colluded with various medical charities to boost the sale of their very expensive drugs. Okay, the allegations was basically made by a former staff, and the staff had claimed that Celgene had donated lots and lots of money to the various charities to enable them basically also to take certain causes of action that then gave them grants and allowed them to then also buy the medication. So it was a fairly complex, in a sense, structure. Without the complaint by the employee, the staff who was part of this whole process, the case would never have come out and the investigations would never have happened. Now, another rule to note is when drug companies provide donations, it's meant to be blind donations. They're not supposed to know where the funds go, what it is utilized for, and so on. But here it was directed for utilization in a certain way. Now, as far as Singapore is concerned, in this particular industry, there are very strict rules. So we don't have to worry too much about this aspect of it. Still on pros, just very quickly, I'm putting out some. One of the key things, like I highlighted, is fraud detection. So without whistleblowing, you're not going to have this occurring. And in, I think, 2 or 3 months ago, if I'm not wrong, Minister for Law announced the new Corruption Reporting and Heritage Center having been set up in Singapore. So it's basically now to allow members of the public, not employees, to lodge corruption complaints discreetly and easily. And this is important. So even in very clean Singapore, there continues to be allegations of corruption. So this is intended to manage that. And just now we showed you charities which have implemented policies. These are some government agencies which have done so. Cons of whistleblowing. I won't spend too much time on this. It's really sometimes a question of whether the whistleblowing is effective. So sometimes the way the whistleblower brings up the facts, it could be my opinion rather than supported by facts. I've sort of alluded to this. And that can actually cause, it's unnecessary opportunity costs spent in trying to investigate cases. And then again, it comes up to, do I have a spurious case or is it a genuine case? I'm not happy. Actually, this happens so often, you know, and people will believe what they want to believe. I'm not happy with you. Whatever you say henceforth is going to be negative. I will always look at it a certain way. You know what? I'm going to go and complain to big boss about you did this and you did that and you did this. And that kind of thing is spurious, but it happens. And it's unnecessary. So that's another con of whistleblowing. Whistleblower retaliation, so this is looking at it from the perspective of the whistleblower. I've talked a lot about this, I won't go into it. Harassment by co-workers. So after I've whistleblown, other workers don't like me anymore. So again, I've talked about that. And it's not just about difficult to work in the organization, it's about the harassment that could come from that. And then ineffectiveness of the remedy. So I whistleblow, so what? Did the issue get solved? Sometimes yes, sometimes not. And I think we're not at the level where it gets solved very easily. One quick example, I mentioned about harassment or being dismissed. This particular case, the whistleblower essentially had seen a company loading unrecovered waste oil in one of their motor tanks, and this is in breach of the law, in breach of the Maritime and Port Authority Act. So what he did was he went to report this to the police. The company was convicted. There was a penalty paid. But what happened here was his name, IC, address were included in the open court documents. Exactly. And then he and his victims basically became, were harassed by others, by public, by presumably the company itself hiring people. You see some of the things that happened. Paint was splashed on his door, potted plants were smashed, they had threatening phone calls in the middle of the night. So what he did, and this was 2 years ago, this particular case, he went up to the MPA to claim compensation. And they said, too bad, you can't claim any compensation, there's no confidentiality obligations owed to you because you didn't come to us first. So this was an employee. What you did was you went to the police directly. So there's no confidentiality protection, and there was nothing wrong with us making the name public. Unfortunately, this is true. So if we were in Malaysia or in the UK, the the Public Disclosure Protection Act in the UK and the equivalent in Malaysia would have accorded this individual protection. Still on a con, another old case. This was something related to, it's very old, but it's interesting to talk about. So it's basically a charity that was looking to award a building contract. Okay, so they were going to award the building contract. And a construction company offered a gift. So it's called a gift, but we all know what it is, right? So one of the individuals of the company, of the charity, reported this to the trustees of the charity. And he did the right thing. But after reporting it, he was ostracized by the charity and he was sacked. And then when he went up to the charity commission, they refused to meet with him. They refused to talk to him. And basically, they took the view that he was no longer an employee of the charity. What he could do then was only go to the press, right? And when he went to the press, the story broke and everything, it becomes a case of his name coming out. It means it becomes very hard for him to find another job. So that's another sort of consequence of this whole issue. Now in the UK, this would not have happened because this is 1992. But it's just other countries, including Singapore, something like this could happen. And Singapore is so small, right? Things get around, sadly. Now this one, I'm near the end of my deck of slides already. This one is a little bit more recent. You might have read about it in the papers already. So we had a case of the Barclays chief executive who basically had tried to unmask who the anonymous complainants were, whistleblowers were, of the bank's activities. He used the bank's internal security team to track down who had written the two anonymous letters to the board, making allegations about a long-term associate that the chief executive had brought into the company. And he said that it was right for him to do this, it was fair for him to do this because these two anonymous writers were harassing that particular associate. The issue is still being looked into, so there's no final results. But what we do know is that the head of the blowing unit at Barclays basically left the bank. So the question is, did he leave the bank because the name of the whistleblowers got leaked out eventually, or what? What was the reason for the leaving? We don't know. And the case is still pending, so let's see how it turns out. Ineffective remedies, I talked about this quite a bit already. This is directly in the charitable organization. Won't go into details of it. Actually, will go into details. This is again about an employee who complained about concerns that were going on, breaches in relating to charities, the charities laws. When the Charity Commission requested for information of the company, of the charity, the particular employee was dismissed. And when she was dismissed, what was the reason given? Poor performance. I do a lot of employment law as well. Poor performance is not easy to establish. I give you that assurance. If you as companies keep proper records of your employees and so on, and if you are employees, I just want to give you the assurance that it's not so easy to dismiss you just on poor performance. There must be a record, okay? But in this particular instance, she was dismissed, but she sued and she got, because of the protection, she did get reinstatement of her job. No, sorry, she got damages, but she didn't get reinstatement of her job. Now, everything that you see on the slide I've already talked about, so I won't go through it in detail. Challenges to whistleblowing. Basically, it has an impact on how the organization manages things. There are challenges in terms of, we keep saying it's a very Asian thing, but again, I think the more you travel, the more you realize whether it's the West or Asia, it's the same. It comes down to trust. I need to trust you. If you whistleblow on me, it kills it. It goes into the whole point about I mind my own business, you mind your own business. That's another challenge that we have. We have negative perceptions of telltalers, and so on and so forth. I won't run through this because I've been talking about it already. So what can be done very quickly? Protection. Really, should we do away with whistleblowing? The answer is no. We must have whistleblowing. But what can be done to ensure that the whistleblowing is effective? You need to ensure that there is proper protection. Can it be done? The answer is yes. Proper protection can be put in place. Proper protection means adequate enforcement. There needs to be enforcement. No use having it in the law if there's no follow-through. There must be follow-through. This is a case out of Malaysia where an ex-CEO had basically sued the employer. Now, what he had done was exposed his colleagues in relation to financial improprieties to the anti-graft body. You know, they have an anti-graft body in Malaysia. He also did it to the, reported to the police. There was an internal investigation against him for alleged misconduct. That's the reprisal that he faces. He complained, so they investigate him for misconduct. He sought protection under the Whistleblower Protection Act. He was granted protection. The High Court looked at the case and said that the employer could not show that there was any, that the actions taken by the CEO, the actions taken against the CEO, so the whole investigation that he was acted in with misconduct was actually clearly in reprisal to his reporting the whistleblowing activity. So he got protection, and it's a good case. Now, finishing off, essentially, like I said, it's having proper measures to motivate, assist whistleblowers. You need to have that effective system. You need to put in the policy. You need to train your people. So the training is important. You need to have a culture of speaking up. You can do this through legislation. I think it's important, but also through the organization itself, because a lot of this is managed internally. Okay? All of this I have talked about already, so I won't go through them. So, last slide. I will leave it at that slide. Okay? I don't need to repeat what's there. Basically, having a policy, communicating, making sure that there's adequate protection. I talked and talked and talked. I usually stop and say questions, but never mind. I will hand it over to Melvin to ask the questions. Thank you.